In the wake of the not guilty verdict in Karen Reed's retrial, David Yannetti and Robert Alessi have been making their rounds on the LawTube channels that covered the Karen Reed case. Now, as you know, Brother Counsel Studios right here, we covered the case beginning January of 2024, all the pre-trial stuff before the first trial. We covered the first trial and all the appeals, and then the Supreme Court, and then the Daubert hearings, and the pre-trial for the second trial, and then the second trial. So we covered the case extensively. I did reach out to Robert Alessi a couple of days ago. We did have some email communication and exchange, and it seemed, at least initially, that they were interested in coming on to Brother Counsel. However, since a couple of days ago, it's been kind of radio silence, so maybe they are having second thoughts, which is unfortunate, but of course, they have the freedom to do whatever they want. Now, it could be that I'm just not big enough, and they got to go to the bigger channels first, but hopefully they will revisit and come back to that decision and come back to Brother Counsel Studios so we can have our discussion with them. I assure you it's going to be a wonderful, great discussion, and I will try my best not to ask all of the questions or any of the questions that other law tubers have asked them. We'll go to other topics. Now, I still did see some of the other interviews that they did with some of the other law tubers. So, for example, Runkle DeBailey, they went on Lawyer You Know, and then last night, Melanie Little. So it was very interesting. And to me, as a lawyer, what talks to me the most is talking about the evidence, talking about the strategy, who to call, when to call, why to call. The strategy is really what talks to me, which is why, to me, the last night's interview with Melanie Little, to me, was the most interesting and informative. Now, of course, all the interviews are great. Go watch them. Runkle DeBailey and Lawyer You Know, they're all great. But I'm just saying what talks to me the most is when you're talking about strategy. That's what I like to talk as a trial lawyer. That talks to me. And we got some more interesting answers to some of the questions that Melanie Little asked about certain questions of strategy, which is why we're going to be focusing mostly on Melanie Little's interview. The first thing that I want to talk about actually is something that Lawyer You Know pointed out, and that was that there was some sort, well, he asked this question, but there was some sort of gentleman's agreement between Hank Brennan and Alan Jackson or the defense team to let each other know what witnesses are going to be called the next day. Some courts, they require this. Like if you're watching Brian Koberger's case, if you plan on watching that, the judge already ordered that the attorneys at 5 p.m. the day before have to disclose to the other side which witnesses are you plan on calling the next day. If you have 100 witnesses on the witness list, how is the other side supposed to prepare for that? It's kind of like trial by surprise, trial by ambush, as we keep hearing that term thrown around. So some courts require it. In this case, it seems like they had a gentleman's agreement about it. But let's move on now to really mostly Melanie Little. We'll talk a little bit about Runkle Bailey because he asked one of the questions that Melanie also asked. So we'll compare the answers. But the first thing that that I want to talk about, that Melanie discussed with them, was the Crosby versus Russell issue. And this is something that we focused on our channel a number of times, and that was the fact that there seemed to have been a contradicting order from Judge Cannoni regarding Dr. Russell when you compare it with Dr. Crosby. Dr. Russell's a real doctor, an ER physician for 30 years, a forensic pathologist for 30 years, and she had to go through a 2-day Daubert-Lanigan hearing. Dr. Crosby is a dog behavior expert and not a medical doctor, and all of a sudden he's allowed to opine on causation, which again is a contradicting what Judge Cannoni's ruling was in the first trial, and he gets rubber stamped without any sort of Daubert-Lanigan hearing. So everybody was up in arms about this. You've no doubt have heard me talk about it and other law tubers talk about it. So here, fair question. I think it's a great question to be asked. What did you think about this? What did the attorneys who are handling this? Well, how did you react when you heard that type of news? Now, what Robert Alessi did was masterful, and this is what attorneys are very good at. He kind of dodged the question, but he did say that he welcomed the fact that he's able to do a Daubert-Lanigan hearing with Dr. Russell. Now, why is that? Well, for one main reason, and it's a reason that we spoke about at length in our channel. Maybe this is where he got the idea from, but it's something that we spoke about, and that was that, remember, in the first trial, Dr. Russell was limited to discussing or giving an opinion about whether the injuries to John O'Keefe on his arm are consistent with a dog attack. But she was not allowed to testify that they are inconsistent with a motor vehicle strike. That's what she was limited to. Why is that? Well, the reason for that is because she came in the middle of the trial, and yes, they had a Daubert-Lanigan hearing, but Judge Cannoni, to kind of even it out, said, okay, then you're going to be limited to talking about the dog bites, that they're consistent with a dog attack and that, or an animal attack, and that's it. So I've mentioned a number of times, if you've been watching this, then you know this. If you've been following me, then you know this, that I said for the second trial, the defense should make sure that Dr. Russell could also opine on the fact that these injuries to John O'Keefe's arm are inconsistent with a motor vehicle strike. I said, that has to come out because now it's not in the middle of a trial anymore. It's not trial by ambush. It's not a surprise. And she's definitely qualified. She's an ER doctor, forensic pathologist. She's definitely qualified to give that opinion. So that's something that Robert Alessi answered, saying, yeah, I welcomed the opportunity for a Daubert Lanigan hearing when it comes to Dr. Russell, because then I could establish that she's qualified as an expert to not only give an opinion about the animal, about the injuries to John O'Keefe being consistent with an animal attack, but also that they are inconsistent with a motor vehicle strike. So that was why he welcomed it. Now, he didn't really get back to the original question, which was, well, what about the difference between Crosby and Russell? Why was Crosby rubber stamped? What do you think about that? But, lawyers are good at dodging questions that they don't want to answer. But, okay, so that was one question. And it could be he doesn't want to talk about it. And I think that we're finding from these interviews, they're being very careful not to put Judge Cannoni down, which is, again, admirable. And maybe that's what they decided before. They're not going to say anything negative about Judge Cannoni, which is fine. And if you're David Yannetti, you don't want to, because there's a very good likelihood that you'll be practicing in front of her tomorrow or the next week or the next month. And you don't want to have anything negative that you said about this judge, and then you're appearing in front of the judge. So it's understandable, and maybe that's what they want to stay away from, and that's completely their right, and they could say that. And by the way, they probably have some sort of rules before you interview them, which, of course, we will abide by. If you want to come here back to Brother Counsel, I think you should reconsider. But if you do, then, of course, whatever the rules are, we're going to follow the rules. But anyway, so that was his answer with respect to Russell. Now, there's also another issue that he brought up with Dr. Russell, which is something, again, that I stressed on this channel. And that was, it comes to the following. When it comes to Karen Reed's statements and the fact that some witnesses heard her say, I hit him, like Flamati and Nuttall. And I'm sorry, was it? It was Nuttall and it was McLaughlin, right? So when you have these paramedics, and really, they should be objective witnesses. They don't really have a dog in the fight. And they say that they heard Karen Reed say something, right? So you could argue to the jury she never said it, which was the posture in this case. Now, I've always maintained from day one that the stronger defense for Karen Reed is not that she didn't say it, but that she was beside herself with grief. She was grief-stricken and she was hysterical. And by all accounts, the scene was chaotic. She was beside herself. She was going crazy. She was hysterical. She couldn't calm down. She was screaming around. So that type of person that blames themselves cannot be taken seriously. It's not a calm, collective confession, right? So, and I even suggested that maybe get an expert to testify to that effect. You can get an expert to say, yeah, this is very common. And when someone's going through grief or sudden grief or extreme grief, this is a common reaction. This was one of my suggestions. And then what happened was, as Robert Alessi said, is that when Dr. Russell was on the stand and it got brought out that she reviewed the medical records from Good Samaritan and included in that, not included in that, but did she also consider, not the medical records, we're going to go into did she consider the fact that Karen Reed said, I hit him? So even though I understand that it's not documented anywhere and I understand all the arguments, don't worry, trust me, I understand all the arguments. I still think it's a stronger argument to say that she may have said it, but she said it in grief, not as a confession. And that's kind of what came out with Dr. Russell's testimony, because she said, yes, I did consider it, but because when someone suffers from extreme grief, it's a common reaction for them to blame themselves, to self-blame. Well, then that's why I didn't really consider it so important. And that really is what they could have ran with. But again, the defense, in this case, they postured that she never said those statements. And then it's always harder when you're asking the jury to believe that she didn't say a statement when you have three witnesses who said that she did hear it. And so, if you want to try to create a reason while each of the individual witnesses are not credible for whatever reason, okay. And then one was manipulated and the other one was lying and the other, it's just harder for the jury to believe, as opposed to, it makes a lot of sense. People blame themselves all the time. So again, from day one, I've been maintaining that was the stronger argument. And it seems that Robert Alessi kind of agreed with that, but he did say that came out from Dr. Russell anyway. Okay. Let's move on to Proctor, because this is also a big question that came out, was should the defense have called Michael Proctor in their case, right? And really, Runkle brought this out in his first interview with them, and you can definitely see the difference in how they answer Runkle. He was the first interview, so it could be they're more guarded, it could be that they're not, they're being more careful. And when it came to Melanie Little, they gave us a little bit more information. Maybe by the time they come on my channel, they'll give me even more information. Who knows? But when it came to Runkle, listen to the answer to how they gave the answer to the question of calling Michael Proctor.
one of the big decisions and one of the huge sort of moments was you guys decided not to call Trooper Proctor. I know there was a fight over, getting, and you guys did great work on, getting Proctor's texts in and so forth. But there was a decision not to call, and this was probably the most contested decision among sort of the law tube community. And so, can you talk about sort of that decision and like why that was, why that was made? What was the thinking there?
You go, Bob.
Yeah, we can't speak much about that issue, as I'm sure you can imagine. It is one of the questions, so you asking it is perfectly understandable. There was, as you can imagine, considerable discussion about that topic, but not unfortunately able to go into the strategy behind it. But I will say something. There were significant evidentiary battles.
Okay, so he's saying he doesn't want to get into it. They can't get into it, and there's really no reason why they can't get into it. I mean, it could be they just made their own kind of agreement. Like, there's no, there's no like protection that they're not a lot of, there's no like order that they can't talk about it. This is strategy amongst the attorneys, so it could be they made up amongst themselves that we are not going to discuss this strategy with the public. But okay, that's their decision. They're allowed to do whatever they want. But this is the decision that people want to hear. They like to see why yes, why not. Without even saying who said what. Why don't you just walk us through some of the thoughts that were going on, some of the discussions that were going on about whether yes to call them or whether not to call them, right? So, without saying names, what you can't do that for us. Okay, but again, whatever they decide, you can't talk to them about. That's fine. Everyone can make their own rules. And that's fine. I think that would be very interesting to the public to hear what these, three really great trial lawyers, what their thought process is, whether to call Michael Proctor or not. So that was that. And then he also did want to give a little shout out, Robert Alessi, want to give a little shout out to David Yannetti that, what was very important was that the text messages come into evidence. So, he was saying how David Yannetti was able to use his expertise and authenticate those messages with another person who was part of the communication and call his friend, as we all remember, that friend who came in and authenticated the text messages, and there's some argument about it, and there's some case law. Okay, so yeah, there's some, David Yannetti took care of that, made sure the case law was solid, and he was able to get these messages into evidence. Nevertheless, the question about whether to call David Yannetti, to call Michael Proctor, still looms large in a lot of people's minds, and they don't really have a great answer. So Melanie Little, we did get a little bit of a better, a fuller answer, and this was from David. Maybe that's why. So this is from David Yannetti giving the answer here instead of Bob Alessi. Maybe that's why we got more of an answer. But listen to how he answers the question here. I just want to make sure that I am up to the right part. I'm not sure if I'm there. Let me just make sure. I think I got to go to 39. Here we go. Okay.
Do we allege, they did anything wrong? I had a decision to make, which was, once it became clear that the DA really was not going to call the lead investigator, it was imperative for us to get those text messages into evidence. That was integral to our defense. And, if we couldn't get them in through any other witness, we may have been in a position where we had to call Michael Proctor. And boy, we didn't want to. We had him under subpoena, but I did not want to put him on the stand. And I said in open court.
Hey, you hear what he said there? Boy, we did not want to. And then he said, I did not want to put him on the stand. Now, I know maybe some of your behavioral, panelists, whatever, will look into this and say, well, maybe it seems like David Yannetti was the one who said, I do not want to put him on the stand. Maybe, again, I don't know. I mean, if you want to read a lot into what the language there is, that's for you to do. But first he said, boy, did we not want to put him on the stand. And then he said, I do not want to put him on the stand. Okay, just pointing it out there. But let's continue listening, and then I'll give you my thoughts about it.
What I had been thinking, what we all had been thinking behind the scenes, which is
what I've been thinking, what we've all been thinking. So like it seems like, and again, this could be just speculation, and I'm not a word expert or how to be able to analyze all this stuff, but there is some of I and we's being switched around here.
That, we would, even if we were able to have him qualified as a hostile witness and lead him on direct.
And by the way that he's setting this up, okay, even if we'd be able to get him qualified as an adverse witness or a hostile witness, which of course you would. Everyone understands that Michael Proctor, the lead investigator, is trying to lock up your client for life in prison. He's not an adverse witness. He's not going to be a hostile witness. You're not going to be able to lead him with leading questions and treat him as an adverse witness. Of course you would be able to. So it sounds like he's trying to explain and give like reasons why, these are not such great it's not such a great idea to call Michael Proctor. Which, okay, the first reason, again, that he may not be treated as a hostile witness, that doesn't fly with me, I think, at all. But let's continue listening.
Hank Brennan would be able to cross-examine him, and he'd essentially be able to give 2 closing arguments in the trial. And he would necessarily, because he's a skilled lawyer, somewhat rehabilitate Michael Proctor, who, through that point in the trial, there was no sympathy for him in that courtroom at all. So we wanted to desperately avoid that. Now, so I'm balancing that against the fact that I have, these.
Again, you see the we and the I. So we desperately wanted to avoid that. And then he goes back to I. So I really wanted to weigh that, so it could be he was behind this, but let's just continue listening.
For innocent, friends of his from high school on the thread under subpoena.
Okay, so now he's going to get into the fact that they're able to get in the text messages, right? The text messages is very important. But so the 2 reasons that he gave is that maybe he's not going to be able to be treated as an adverse witness, which again, I don't think as a trial lawyer, I don't see how the lead investigator who's trying to lock her client up is not going to be treated as an adverse or hostile witness. Okay, that's number 1. Number 2, Hank Brennan is able to give 2 closing arguments. Right, because when you when you try to rehabilitate a witness or cross-examine a witness, you're essentially kind of giving a closing argument, right? I mean, that's an argument that can be made for cross-examining any witness, right? So again, that argument, how strong of an argument is that to not call Michael Proctor? Now, it's true. Now, I will say one part that is true is that Michael Proctor was somewhat of a boogeyman. That's true. He was somewhat of a boogeyman. And, not knowing who he is and not being able to put a face and not humanizing him, there's definitely a strategy there. I'm not taking that away at all. But I will say this, that I don't think there's a way possible to make Michael Proctor likable. When it comes to Brian Higgins, I can definitely hear the argument. We'll get to that a little bit later. But when it comes to Michael Proctor and his text messages in this case and his actions in this case and the bias in this case and the fact that he was dishonorably discharged, and these things can come out with him being on the stand, I don't see any way possible to rehabilitate such a witness. And I remember watching from the first trial before he was dishonorably discharged, before that he was fired from his job for exhibiting bias. Still, even in the first trial, he was so unlikable. There's nothing about him that was likable, just by the fact that he's reading those text messages and he wrote them and saying that it's regrettable and he shouldn't have done it. It doesn't help. The jury hears that and they're immediately turned off and they see it from him and they just despise him. That was the first trial. In the second trial, when also he was dishonorably discharged, he was fired for this. There is a much stronger argument why you should call him. And the fear of Hank Brennan being a skilled lawyer and somehow being able to rehabilitate him, I don't know. I don't buy that argument so well. I just say, now there is another reason. There is another reason why perhaps you don't feel that you need to call him. And that is, well, before we get to that reason why you shouldn't go, another reason why you should call him, before we get to the reason why you shouldn't call him, but another reason why you should call him is because it's so compelling to tell the jury that the prosecution has one job in this case, and it's not to secure a conviction. You all will remember the case law from Massachusetts that I put up on one of my slides when I was doing a mock closing argument, which Alan Jackson could have done, where it says that the prosecution, the Commonwealth in a case their job is not to secure a conviction. It's to show the jury the truth. It's to pursue truth. And how can you possibly pursue truth by not calling the lead investigator in this case? And in fact, ladies and gentlemen, if you're the defense, we did call them because we do care about the truth. The Commonwealth doesn't care, and therefore they didn't want to call Michael Proctor, but we do care about the truth, and that's why we called Michael Proctor, because we want you to know all the information in this case, because there's no question at all that you will acquit our client, and we had to do that for the Commonwealth because they're refusing to do their job. I think that that's extremely compelling. On the flip side, if you're not going to call Michael Proctor for whatever reason, maybe you're scared that they're going to have a closing argument or whatever. If you're not going to call Michael Proctor, then there's something off about the way Alan Jackson presented it in the closing argument, which also makes me feel that there was some more going on, more communications and more conversations and more discussion about this whole Michael Proctor boogeyman. Because I think he could have slammed it home a little bit harder in his closing argument, saying that how can the Commonwealth not call Michael Proctor? How is that even conceivable in a murder case where they're trying to send our client away for life? Well, you don't have to say life because you can't say what the punishment was. But they're trying to convict our client of a very serious crime, and they're not going to call Michael Proctor. And there wasn't that much of an argument. It wasn't as strong of an argument about that, and I don't know why. I'd like to also get some of the answers to that. Now, again, they don't have to answer any of these questions, and that's fine. You can make me a list. If you want to come on the show, you tell me what you don't want me to talk about. I won't talk about it. But these are the questions I think as a lawyer you want to know. Like I would have slammed that home. And if I don't call him, and if I do call him, which I think, again, in this case, probably would have been the right call to call him, then definitely would have slammed that home and said, we called him. We called him because we care about you, the jury, finding out the truth. So there is one reason, again, let's get to the reason why maybe not to call him. The reason why I could understand why you wouldn't want to call him is perhaps because you don't need it. You're so confident in your case that you don't need to call Michael Proctor because he is so unlikable, and there's no way there's no way to rehabilitate him. I submit to you, there's no way to rehabilitate him. He's so unlikable. It's absolutely going to help your case if you're the defense, especially if you're the ones calling him and you can tell the jury we called him because they're too scared to call him. We called him. There's such a strong reason to call him. But if maybe you feel so confident in your case, and by the way, that's not an argument that's lost on me, because in this case, the defense had an extremely strong defense. So if I would hear an answer from the attorneys on this case saying, we didn't call Michael Proctor because even though we knew how strong it was going to be to help our case, we didn't need him. We didn't need him to win our case. So why call him? I can live with that argument. Actually, I could live with that argument because they did have a very strong case. When you look at all their experts and Arca and Russell and whatever, I think there's an argument to be made. But I think calling Michael Proctor, if you're the defense in this case, is so advantageous. And since we don't know what the verdict is going to be, and how confident can you absolutely be in your case that you know for sure you don't need him? It's again, it was a judgment call. Now here's and they made the decision. Look, they won the case, but that would make more sense in terms of strategy. Again, we're talking about strategy. We're not looking back in hindsight. Well, if it was not guilty, so then obviously everything that they did was perfect. That's not the way that you're supposed to approach this. But I also want to make one more point, and that is, I wonder whose decision it was not to call him. Because when Alessi answered the question in Runkle's interview, he said, obviously, there's a lot of discussion about it. Obviously, there was, we had discussions about it, which they weren't just saying discussions of, should we call him? No. Oh, we all agree? Okay, great. There's more discussions about it, right? There's some discussions about, wait, maybe we should call him. Maybe some people felt that they should call him. Maybe Alan Jackson felt that they should call him. I don't know. I'm not sure. And I'm not going, it's all speculation. But I do want to say, I want to tell you how sometimes it works when you have multiple trial attorneys working on a case together. And this is how it works in my experience. Okay. When somebody brings you on as a lawyer, so usually the way it works is that I have the client. Let's say I have the client signed up with me. They have the retainer with me. And I tell the client, look, this is a very complicated case. I need other lawyers to help me out with this case. There's going to be 45 witnesses. I can only do 20. I want another lawyer to do another 20. And the client will say, fine, no problem. I'll pay for it, whatever it is. I have the relationship with the client. It's my client. I make the ultimate decisions. Okay. So I can bring on the best trial attorney in the country. And he comes to my case. It's my case. And I'm going to decide the ultimate decisions like this, whether I call Michael Proctor or not, especially when it's a big decision. That's how I operate. That's when I'm involved with other cases and they're not my cases. I give as much advice as I can, as much help as I can. But ultimately, when we have a discussion about something, when we have a disagreement about something, if it's that attorney's client, it's his client, he brought me in on the case, he's going to be making the ultimate decision. That's just how it works. Now, it could be he'll defer to me. That's fine. But usually, when you have good trial lawyers across the board, it's the person who has the client who makes the decision, which is why, again, it's speculation. It could be that Yannetti had the final word here. I don't know. And again, I don't know if Yannetti was the one who recruited Alan Jackson, or if Karen Reed got Alan Jackson involved, and therefore maybe Alan Jackson's really more, maybe Karen Reed's more his client, maybe Alan Jackson got the last call. I don't know. This is all speculation, but I'm just telling you, sometimes when you have these powerhouse attorneys, who gets the ultimate decision? It's the one who has the client. Okay, anyway, fine. Moving on. Let's talk about Brian Albert and Brian Higgins. Okay, now there was another question, whether they should call Brian Albert or Brian Higgins? Why should the defense do that? I had my opinions about that, and let's see what the answer they give for this is. Okay, here we go.
So, I mean, I spent probably 100 hours preparing for the cross of Brian Albert.
So first of all, David Yannetti was going to be the one to cross Brian Albert.
I hosied him at the start of the trial, and nobody fought me hard enough to win the right to cross-examine him. So he was mine. I have, I mean, legitimately never prepared a cross-examination like that in my 36-year career, ever. I was so ready. And on the one hand, I was very disappointed that he wasn't called, because, you know, nobody will ever see that cross. It's all in my head and in my dreams. But on the other hand, for the good of the case, for the good of Karen Reed, which is always what this is about, you know, it's not about egos. It's not about, you know, personal gain. None of this is about that. It is about what was right for the case, what was right for Karen. And my experience, as I told you before we went on air, Melanie, having tried, you know, some third-party culprit cases, including one particular murder case that stands out to me. My experience has been, and it's anecdotal, and maybe it's wrong, but my experience has been when the government, the Commonwealth in Massachusetts, produces the third-party culprit, it becomes more difficult for the defense to win the case. But when the Commonwealth fails, or in this case chooses not to call potential third-party culprits, it becomes difficult for them to win the case. You know, as I mentioned, you know, when we talked earlier, Brian Higgins in trial 2 was a very different character in terms of how he was portrayed to the jury than in trial 1. I thought it was night and day. Whatever you think about his testimony in trial 1, there is always, you know, an element where somebody is humanized when you hear his or her voice. Think of what the jury knew about Brian Higgins in trial 2. All they knew were those menacing videos in the waterfall. It was pointed out to this jury in trial 2 for the first time that John O'Keefe came over and kissed Karen Reed in a way that was described as so sweet by Karina Kolakifis, right in front of Brian Higgins, who had texted her, well, you know, and it takes on a sinister tone. He's now drinking. The jury can see that he's drinking on the videos. They see that he sees the kiss. And it's after that that he's saying, still insistent, that John, you know, come with them, even to the point where Chris Albert had to grab his arm it looked like he was trying to pull him away. And then after that, you see him kind of skulking about the Canton police station, doing what exactly after a night of drinking at 1:30 or 2 o'clock in the morning, and on the phone with a call that's never explained. I mean, that's what the jury got in trial 2, and they got that because nobody called Brian Higgins to explain any of it. My personal view is I think that hurt the Commonwealth. I think it hurt the Commonwealth that they didn't call Brian Albert. I think it hurt the Commonwealth that they didn't call Michael Proctor.
Okay, so let's just take that apart for a moment. And I have to say that I completely 100% agree with David Yannetti when it comes to Brian Higgins. Brian Higgins, I think in the first trial actually came across well. I think he came across well. And especially the way that the prosecution presented the text messages with him, it definitely seemed like he was the one that, you know, Karen was going after him. She was the initiator. And then, you know, they didn't really show all the text messages, which we saw in this trial. But in the first trial, I think that he came across as likable. You know, so I definitely agree with him, David Yannetti, that in this trial, the defense should not have called Brian Higgins. They don't need Brian Higgins for anything. You know why? Because they already got all the text messages in through Buchanan, which I think if that was a strategy, which I think it was, and again, maybe that's the question I'll ask them if they come on the show. But was the plan always to get the text messages in through Buchanan? Because I think that was ingenious. That was great. And you got the entire context of the text messages that he read, not the selected ones that we saw in the first trial. And you don't have Brian Higgins because I think Brian Higgins couldn't come across well, could come across likable. So you just had this boogeyman who's hanging around the Canton Police Department at 1 o'clock in the morning and 1:30 in the morning. And then he's also in the bar and that he has some sort of flirtatious relationship. You don't know who he is. You know, he's just some sort of boogeyman. Completely agree with you on Brian Higgins, 100%. Brian Albert, again, I'm going to submit to you that is an unlikable person for a number of reasons. Number one, he's just unlikable. On the stand, he looks like a big, tough guy that nobody wants to spend time with. Okay, I mean, whatever, on the jury. Like you're not like your dream guy to spend time with. I don't know if is Brian Albert, right? Brian Higgins, I don't know. Like, yeah, I think he came across a bit, you know, nice and more likable. But Brian Albert just I remember from the first trial just did not come across as likable. Number two, aside from just the demeanor and whether he's just a likable person, number two is that his actions and inactions in this case speak so loudly, and they create such issues, I think, in the jury's minds, that that's also an important part that you want the jury to hear. So, for example, remember the butt dials? Everybody remembers the butt dials in this case. There was no mention of butt dials in the second trial at all. And the butt dials in this case is very, I mean, there was about Jennifer McCabe, but I'm talking about the 2 o'clock in the morning butt dials, the 2:30 in the morning butt dials between Brian Albert and Brian Higgins. Now, I understand that this trial, the second time around, of course, as we've all been saying, and which it seems that the defense took our advice on, is that they shouldn't focus so much on the conspiracy or the cover-up. They should just be focusing on, Bowden defense, how bad the investigation was, and how incomplete it was, and it wasn't full, and they protected their own. Yeah, that was great. That was understandable. It doesn't mean that this type of evidence is going to hurt that type of defense. The butt dials make no sense. The fact that he did not come out of his house makes no sense. Where's the Chloe, the dog, in that point? Makes no sense. Everything makes no sense about Brian Albert in this equation. So when everything makes no sense, then there's no, and he's not likable, then I think Brian Albert is worthwhile calling. And again, it comes back to the Michael Proctor issue. Are you so confident in your case that you don't need the jury to hear about these butt dials and butt answers and butt hangups and all this stuff that was going on with the butt dials, which is, again, ridiculous. And there's so many questions that you can throw at the jury now when Brian Albert takes the stand. And he's just an unlikable person. So I think that would have definitely, I can definitely see the argument that Brian Albert should have been called in this case, more so than Brian Higgins. I think Brian Higgins was a boogeyman. I think Michael Proctor was somewhat of a boogeyman. And again, I still think Michael Proctor should have been called, because you don't know that you're going to get a not guilty verdict. And it's so helpful for the defense. And Brian Albert, I think, is also so helpful for the defense, talking about his actions and inactions in this case. All right. Then another point that Melanie Little brought out was she asked, who do you think was the worst witness for the Commonwealth? And here, Yannetti said Kelly Dever, and Alessi said Buchanan. And between those two, I would say I would have to go on the side of Alessi, that is Buchanan. There was 3 days of his testimony. And again, remember, Buchanan is the saving grace for Proctor. If you're not going to call Proctor, which the Commonwealth had no intention of calling Proctor, apparently, which again, I think was a mistake for the Commonwealth as well. But then you have to have somebody to talk about the investigation, which was Buchanan. And Buchanan was a dumpster fire. It was just, he was terrible, right? We all saw it. We saw 3 days of refusing to answer a question. So Buchanan, and that's all you got. You don't have Proctor, so you got Buchanan, and now you don't have Buchanan. So now you don't have a case. And the jury sees that. So these are the people that you're relying on to win your case. And, Dever was okay. That was not believable. And her demeanor was, very combative with Alan Jackson. As we all saw. She was a great witness for the defense because the jury saw, and also the fact that she created this memory that she doesn't, I understand that part. But I have to say that I think if I had to choose, which witness really destroyed the Commonwealth's case, I'd probably Buchanan. More so than Dever. Okay. Then there was another question which brought out an interesting exchange. We'll talk about it. And you may not like my take on this, but I have to give it to you anyway, because that's what we do on this channel. We stay honest, and I give you what my opinion is. So the question here was asked to Robert Alessi, who was your favorite expert to cross-examine? Okay, so listen to what his answer is here about who his favorite expert was to cross-examine. Because Robert Alessi was obviously brought on to deal with the experts. I think we saw that pretty clearly. Now, obviously, he's going to give advice about the case in general also with everybody else. But his role in this case was the experts. So let's see what he has to say here.
Because, a woman was facing life in prison. But Bob, for you, what was the most fun Commonwealth expert? Who did you have the most fun with? Because we watched you decimate Shannon with one in Burgess. We watched you slice and dice Ian Whiffen, who you got to say that Joe Counsel could have been in the house. I mean, it was artful. What sticks out to you?
Well, there's really two categories. Yeah, there's two categories of experts. As I told the team when I'm crossing experts, my goal is to what I call shake hands with the opposite expert witness. Shake hands meaning get them to agree with me in our theory of the case. And I thought that happened with a number of experts. Ian Whiffen was one. The one I had the most fun with was Jessica Hyde. Jessica Hyde did a bit of tattooing of the defense in the first trial, and she came in with a very confident attitude. She came in on direct examination as sort of the professor teaching, and I know this whole area, et cetera. And
I started out my cross with 4 errors that she made. And it took a while, but I got her to concede on 4 of the errors. And then in the end, got her to shake hands on the Faraday bag, right? That these should have been in the Faraday, because she was so wanting to teach the jury and be right. And after I got her to say she was wrong 4 times, she then wanted to recover. And I gave her all the recovery runway she wanted, because I was hopeful that she would do what she ultimately did, which was agree that how they dealt with the chain of custody of the phone and how they examined it was completely wrong. And in the end, the fun part was that it was almost like we were frenemies, right? Thank you. Oh, you're welcome, Mr. Alessi. And it was kind of like a little bit of a competition of who was going to be nicer to the other one. And then in the end, when she admitted that the way they handled the phone, not putting it in a Faraday bag or Faraday box, and if you remember, and this was sort of the ultimate answer to your question and most fun, when she admitted that, yeah, they should have done it much differently. And then she turned to Attorney Brennan after she gave the answer and conceded it. And it's how I ended my cross. And she turned to him and said, sorry. She mouthed to him, sorry, I had to agree with Attorney Alessi on that. That she was the one I had the most fun with. In a much shorter answer, in sort of a 2 fun moments, was with Dr. Welcher, when he was, and his only could do his Dr. Welcher voice was like, what's possible? Well, it's possible that Lexus could have gone in reverse and jettisoned into the universe. And I said, did you just say that it's possible? And he said, well, yeah, I'm an engineer. Anything's possible. And then when I said to him, I said, and it was just a reaction. I said, okay, let's get back to reality in that. And then David, to the extent you want to hear it, with Dr. Wolf, their neurosurgeon, who I had a completely unorthodox way. And I told the team without telling them what I was going to do. I said, I've got a very unorthodox way I'm going to start this cross-examination. And I did it. So, it's not one phone moment. Those were the 3. But the goal is to try to, neutralize an expert. But in this trial, I tried to do much more than that to benefit the team.
Okay. So you guys are probably not going to like what my take on this is. Okay. So just prepare yourself. But I give you my opinion, and that's what I take away. And I saw this entire trial, and I obviously have the utmost respect for these attorneys. They're amazing attorneys. Definitely Robert Alessi, just an amazing attorney, cross-examining expert witnesses, and just everything was just amazing. But I do want to say this. Okay. If your goal of cross-examining a witness is to shake hands at the end, which is like, agree with your theory of the case. So with Ian Whiffen, where do you see that? Where he said, yeah, technically the phone could have been in the house. Great. You got your point. You shook hands and he kind of agrees with your theory of the case. It's possible. Great. You did your job. Jessica Hyde. Now, again, this is Robert Alessi. You asked him, well, who's your favorite expert to cross-examine? Maybe this was his favorite expert to cross-examine. But if you'd ask me, did he score the most points with Jessica Hyde, or did he score any gotcha points? I would say that not really with Jessica Hyde. And with Jessica Hyde, I don't think she was likable. I think that she was arrogant. I think that she felt that she was the smartest person in the room, and she talked down to everybody, and that she was passive aggressive. I think that there's plenty of issues with her own demeanor, which she kind of did to herself. But if you're asking me skill on cross-examination, the Jessica Hyde issue was, yeah, you found a few typos or a few mistakes in the report, which of course you have to exploit in cross-examination. I get that. But her ultimate opinion was that the searches were not done at 2:27 in the morning. That was her ultimate opinion, right? Ian Whiffen also. You didn't, right? So did you make any progress on that? Did you shake hands with the expert on that point? Not really, because she didn't come off that opinion at all. And her opinion was very strong at the end that no, that search was not done at 2:27. So yes, you pointed out a few mistakes that she made in the report. Good job. As an attorney that you're supposed to do cross-examination, you got to point out some of the mistakes that the witnesses makes. And the Faraday bag, again, it didn't affect her ultimate opinion, which was clear from watching Jessica Hyde. She did say, yes, of course, best practice is to put in a Faraday bag. 100%. That's best practice. Did it affect your opinion? No. Would it affect your opinion in this case? No. It just didn't affect the analysis that I was running on the phone. And therefore, no. Yeah, best practice. Sure. That's the best practice. So in terms of, if that's your goal, if that's what the goal that you set up for yourself is that you're shaking hands with the witness, that was not, or showing that the witness is so not credible. If that's what you're trying to do, is you're trying to neutralize and undermine the witness, the expert witness, then Jessica Hyde, I can't say that he got too far with Jessica Hyde. Again, I said, yes, you scored a point. You pointed out those discrepancies in the report. But her ultimate conclusion was solid the entire time. You didn't really budge her on that, and that was her opinion. Now, you can have your own expert, which if you wanted to, you could have called and said, no, the search happened later, Richard Green or whatever you wanted to call. But, then it's a battle back to the battle of the experts. Let's talk about Dr. Wolf, because you mentioned about Dr. Wolf. Dr. Wolf, It was a very short cross-examination. In fact, I was asked about this cross-examination on NBC Boston, 10 Boston. And they asked me, were you surprised by how short the cross-examination was? And I said, no, I wasn't surprised. And I wasn't surprised because with that type of expert, Dr. Wolf, you're not going to win really on the science. You're not going to win on the medicine. He's an expert neurosurgeon. That's what he does for the past 70 years of his life. He's a neurosurgeon. He knows brains. And what was he there to do? So what he was there to do was say how John O'Keefe died. He died from coup contra coup. Did you dispute that? Was that your point in cross-examination? No. So, okay, so let's move on. What else was his opinion? His ultimate opinion was that John O'Keefe could have lived for an hour or two and he could have been saved possibly. A third of the people are saved from this condition. And that was also what Dr. Wolf's opinion was. Did he get anywhere with that opinion? No. So yes, he did say, you're not a forensic pathologist. Sure, you got him to admit that, and Dr. Wolf right away said right away, "Let me help you out. I'm not a forensic pathologist." But so yeah, you got a little bit of a point there. But with Dr. Wolf, you didn't really shake hands with him at the end of the day if that's what your goal was. So again, I know you're not going to like this, you watchers, you're not going to like this, but and if you're asking me which was the best parts of cross-examination for Robert Alessi, or the funnest part, Dr. Welcher for sure, right? Getting him to talk about a car shooting off into space, that's fun. That's great. You got an expert to say that in a trial. That's fun. How about Shannon Burgess? I mean, the way you made Shannon Burgess look like a fool about it and lying on his CV, that was a lot of fun, wasn't it? So, again, if your point is to completely discredit the witness and destroy his case, so then that happened with Shannon Burgess and Dr. Welcher. The pain test was ridiculous. Everybody knew it. And when you get to cross-examine on that, you did a great job, Robert Alessi, and I'm shaking your hand for that. In terms of, Jessica Hyde, I think that, again, like I said, in Dr. Wolf, you may have made a few decent points, but it wasn't like that was your shining moment. I don't think so. I don't think Jessica Hyde was likable at all, and maybe the jury didn't like her. But anyway, that's just my opinion, and that's what I'm giving to you because that's what you've come to expect from me. But I think that his job, Robert Alessi's job on Burgess and Welcher was masterful. I think that was great. Completely undermined their case. And remember, also, just another point is that the jurors that have come out that I've heard said that they believe Jessica Hyde. They believed her that said that the Google search didn't happen at 227. That's not why they found Karen Reed not guilty. So that's just another thing to keep in your mind about when you're talking about, neutralizing an expert like Jessica Hyde or Ian Whiffen, which is why, by the way, I've never on this channel, I've never concentrated so much on the 227 search. I never really concentrated so much on it because that really is just more about the conspiracy and the whole, third party culprit, which is, I don't think it's necessary. And like I said, you got these other experts that are saying that what didn't happen at 227, so, okay, experts versus experts. And then, you're back to that. So it wasn't like such a big deal in my mind at all from the beginning of this case throughout the end. It's all about, to me, about the collision of the car, which that was for Dr. Welcher and Shannon Burgess, which I think Robert Alessi did an amazing job with. But okay, so that was really most of the substance of the talk about strategy and witnesses and things like that. They got into some other issues also with Melanie Little, some, just like his workout regimen and the type of music that they like. So if you want to see that, you can definitely see the rest of that video. But this is really the takeaways that I enjoyed from these interviews, and hopefully we'll see more. I'm sure we will. But again, David and Robert, Bob, respond to that email. Get back to me. Let's do this. Let's put it together. And we'll have a good time talking about this case. And whatever you don't want to talk about, we won't talk about. No problem. Whatever's off, off grounds is fine. Whatever you set the parameters. We'll discuss it. And I think a lot of people are going to enjoy it. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.